A lawsuit seeking more than $3 million from Charlotte Hornets star Lamelo Ball is set to go to trial. The suit is tied to allegations that Ball injured a child's foot while leaving the Spectrum Center nearly 3 years ago.
According to the suit, Ball hit a young boy with his car, causing serious injuries. Ball is then accused of leaving the scene after the incident. The lawsuit is seeking $3.75 million in damages. The trial is scheduled to begin June 15th.
Now we want to bring back in our chief legal analyst, Khalif Rhodes, to take a look at this, Khalif. The incident in question, it's an area where fans often congregate to try to get fans' autographs as they leave in cars. The question of whether or not the boy was in the road or not, or in an area he shouldn't be there, that's part of this. When you see that dollar amount, though, is that really high? What do you think? Because that seems like an eye-popping number.
I mean, it's a number of things. You get to that number by the damages that you have incurred as a result of the alleged incident. And so if that person, again, duty, breach, causation, damages, that causation is but for, and that individual, Lamelo Ball, is the proximate cause of this child's damages, then yeah, you can point to surgeries, you can point to potential loss of earnings, you can point to potential current earnings, future earnings. There is a number of things where you can get that calculation. Folks that are way smarter than me that have been doing this for a long time have figured out a way to come up with whatever number they believe would adequately make them whole. Again, it's about making the person back to where they were, but also compensating them for what potential loss they may have in the future.
As a defense attorney, take us inside the minds of Lamelo's defense team here, because they're wanting to split this trial kind of into phases, right? They're wanting to talk about liability first and then damages. Kind of work us through that. Well,
and I've been on the family side, I should say, I've filed personal injury claims a number of times in the past as a plaintiff. On the defense side, attempting to defend these types of claims, the bifurcated trial portion of it, having to determine liability and then having a separate portion to determine the outcome. I mean, it gives you at least a second hit at it. You determine, and folks will have an opportunity to look at these from two separate lenses. So I think it helps and cut down on that $3.75 million if he's ultimately held liable, and it allows you as the attorney to just focus on the liability part. Remember, our state has a unique standard for the law, which other states don't follow. We're one of only 5, which is that contributory negligence. Most folks will have comparative fault. So contributory negligence, having that opportunity to say, if this kid, which his team is alleging, was at fault, then he would be completely barred from being able to recover any amount in our state. There is an exception to that called the last clear chance, where he had an actual clear chance to avoid it and he didn't, but that's even harder to get around. And so what I could say is their team, Lamelo's Ball team, would be arguing, hey, even if I was in the wrong, which they're saying he wasn't, but even if I was, this kid was also in the wrong, and because he was in the wrong, he's barred from recovery.
Are you surprised that this case has made it to this point, right? Going to a trial instead of maybe a settlement, or of Lamelo's team saying, we really did nothing wrong here, and this is how confident we are that we are willing to send this to a trial instead of just giving you money?
Yeah, I am a little confused. I typically, with something like this, you just wanted to go away, and you wanted to go away as fast as you can, right? And so originally, this case is doing what you want to avoid. They went through the process. Judge Trosh, who I know well, allowed the plaintiff's team to get access to Lamelo's Ball medical records. Those are types of things you don't want to have. The medication that he's taken in the past, you don't want that to be going through the discovery process, and now you don't want that to happen in a trial. And so that's why it would be encouraged early on to try to get rid of a case like this. Go ahead and settle, admit no wrongdoing, pay whatever fee. It probably would have been significantly less than this $3.7 million, but it would have been behind you. And now the medication, the prior bad driving acts, all of those things will come out in the middle of a trial that you don't want.
Where do you go from here, Khalif? Is it too late to try to reach a settlement before more of this comes out there? Because again, you can see where Lamelo's saying, did nothing wrong, the light was green, I went. What do you think happens now?
Absolutely not. There's never too late for a settlement. Let's be clear. You can have zero talks of settlement. You could be 8 million miles apart. You could pick a jury, get there day one and say, you know what? Let's go ahead and close this up. And I've seen that happen where folks start trial, they start jury selection. The next day they come back and say, hey, Your Honor, both parties have agreed to settle. And back to stories that we've talked about in the past. They let the court know we have a settlement agreement in place and we want to go ahead and dismiss the case. So that can happen. Likely will happen.
Okay. There it is. All right. Our chief legal analyst, Khalif Rhodes, weighing on that. Khalif, thank you.
Queen City News Plus. Just search Queen City News on your smart TV's app store.